Dumelang! Welcome to my channel, Botswana Thinking Law, where I bring you and the law closer. Today on this channel, we're going to be talking about service. I'm sure you've heard me talk in my other videos about service of court papers and so on. And today, I'm going to give a breakdown of what, in terms of the law, is proper service. And here I'm going to be talking about service on natural persons, service on companies, partnerships, and associations. Before we get started on this video, I'd like to put in a disclaimer. This is not legal advice. This is simply a sharing of general information. If you have a problem of a legal nature, please engage the services of an attorney. I also wanted to let you know that the video also has timestamps. And if you're on a laptop or computer, if you're looking at the video, you'll see at the bottom of the video there's a broken line there. And every time you go to a certain portion in the broken line, you'll see that it's a specific topic. So you can use that to skip to different topics on the video. Or if you're also on your computer or laptop or on your phone, you can go to the description. And the way to get to the description when you're on your laptop or computer is to go to show more, scroll down from the socials, you'll see the time codes. If you're on your mobile, just press the arrow button and it will show you the description. You also scroll down until you get to the time codes, and then you just press on the blue portion on the time codes and it will take you to that particular time and topic on the video. Now back to our video. What is service? Service is where a person in a matter has to give documents that they have filed with the court to the other people in that same matter. An example is where a person brings a matter as an applicant or a plaintiff, and they're suing someone who is a respondent in applications or a defendant in actions, and they then have to serve this person or people with the writ of summons. After the service of the writ of summons or the application starting the matter, then there are other documents that are exchanged between the parties. This exchange of documents is what is called service. Now, in terms of the law, there is a time when service can be done, there is a day when service cannot be done, and service, in order for it to be proper service, has to follow certain guidelines. In relation to service of a company is served with court papers when a matter starts. Now, when a matter starts against a company, it can be either by the application or by summons. That originating process, which is the process that starts the matter, has to be served on the company that is being sued. And service of these type of documents can be done by going to serve them or leave them at the company's registered office or headquarters or principal place of business, and they have to be given to an employee who is apparently in charge of that premises, and this person has to be at least 16 years of age. If the employee refuses to accept these documents, then it will be enough to simply paste or put these documents on the front door of this principal place of business, registered office, or headquarters. And when we say registered office, we mean the office that is indicated or shown in the company documents as the registered office. In some instances, the registered office of a company can be at the company secretaries, but this is not always the case. Meaning that if you have served at the company secretaries, it is not proper service unless you can demonstrate that the company secretary offices are also the registered office of the company. A company can also be served by serving a copy of the originating process on the company's director. And this is a director who is recorded in the company records as provided for at the Registrar of Companies. So if you want to serve company ABC, but you can't find the principal place of business, you can't find the headquarters, or you can't find the registered office, you then go onto the company's website, look for the directors of the company, and go and serve the director. Even if you serve one director, that is proper service. A company can also be served at a place where the company has agreed to be served. An example is where a person is negotiating with a company in order to try and settle a matter before they even approach the court. If the company says, look, if you decide to go to court, then you can serve us at the offices of our attorneys. Then, if the person brings a matter and they serve at the offices of the attorney, that in terms of the law is considered to be proper service. Now, later on in this video, I will be talking about what has to be filed with the court to indicate that papers have been served. In respect of natural persons, service can be done, especially when the matter is starting off, where you've brought an application or you've brought an action, by serving those court papers directly on the person that you are suing. Or you can serve at their place of residence, if that is known to you, or their place of employment. Meaning that when you get to the place of residence or the place of employment, you have to serve these documents on the person who appears to be in charge in the event that the person you're looking for is not available. If you go to serve at their place of residence and the person who appears to be in charge refuses to accept service of these documents, then a copy of the document you want to serve can be affixed to the door of the place of residence, and that will be sufficient service. This is also true where a person stays at a hotel or a boarding house. Whatever area they are occupying, for example, the hotel room, they can be served with documents there. And if in that hotel room the person is not present, but there's someone above the age or seemingly above the age of 16 who seems to be in charge in that area, can be served with these court documents. If they refuse, then the court documents can be pasted or affixed on the door of that room. Now, it's sometimes problematic in this instance because the person might come to court at a later date after things have happened and claim to have never received service and claim that they were never in that particular hotel room. And that's the reason why when it comes to originating process, it is preferable to serve directly on the individual. Now, in matters involving a person's freedom or liberty, such as an application for civil imprisonment, that application has to physically be served on the person who the application is brought against. That is the respondent. And the reason why this is important is because you need to show the court that if you take away this person's right to freedom and imprison them, at least they were given an opportunity to oppose the matter. In relation to service generally, if a person refuses to receive service in their personal capacity, and in this instance I'm talking about the actual person in the papers, then it is sufficient service to simply leave the documents on the ground in front of full view of this individual. This will be proper service in terms of the law. And this can be the case whether you see the person at the mall, whether you see this person at the bar, of course subject to the days and times allowed for service. If a person is served with originating process and they decide to oppose or defend the matter, then service will be done at the chosen address of the person who started the matter. And remember in my previous video when I talk about court process for both applications and actions, the person who starts the matter has to indicate the address where they will receive all court process. And the same is true for the person who is opposing or defending the matter. They have to indicate the address where they will receive documents for the matter going forward. This can also be in the form of a postal box where the person will then send the court documents by registered post and attach a slip for that registered post as proof of service via the registered post. Now, if you choose to have a certain address for service or receive of court documents, you have to make sure that that address or post box is available to you, because you might find that you don't receive court documents because you don't have control over that particular address or place of residence or even post box. And you end up finding that you have default judgment granted against you. In addition to that, refusing court documents does not mean that there isn't proper service. And as indicated, someone can leave the documents directly in your full view. Then that is proper service. Refusing to accept that document or those documents does not mean that the matter will not proceed. So it is best for you to accept court papers because it is important for you to know what is being said against you in order for you to respond accordingly. When dealing with partnerships or voluntary associations, service can be done at the place of operation, and the service has to be done on the partners in terms of the law or one of them. And if it's a voluntary association, then on the chairman of the association or anyone that is known to you as management of the association. The same is true for local authorities. And by local authorities, I mean your city council, your land board, and so on. At the land board, it is sufficient service for you to serve on the board secretary or the assistant board secretary. It is also sufficient when it comes to local authorities such as the city council to serve court papers on the mayor. It will be considered to be proper service in terms of the law. Now, earlier on, I was talking about the proper time and day for service. In terms of the law, court papers cannot be served between 7 p.m. and that is 7 at night, and 7 a.m. that is 7 in the morning. And they cannot be served at all on Sunday, meaning that court papers can be served between Monday and Saturday within the hours of 7 a.m. to 7 p.m. In other words, from morning to afternoon to evening, you can serve. But between 7 in the evening into the night and 7 in the morning, you cannot serve. However, there are certain instances where service outside of these times is allowed. And an example of this is the warrant of arrest. A deputy sheriff can actually arrest a person outside of these prescribed hours, even on Sundays. The deputy sheriff can find you at church and arrest you where there is a warrant of arrest that has been issued against you. And when I talk about arrest in this instance, I'm talking about arrest for civil imprisonment for debt. If a person has appointed an address that they want to receive court documents at, then the court papers have to be sent at that particular address. The only exception is where you are able to serve the person directly into their hands. When a person is suing a trust or is suing a company under liquidation or an estate, and there is more than one person appointed as the executor of the estate or as a liquidator of a company and so on, then each of these people have to be served personally. It is not enough for you to just serve one person and consider that to be proper service. You have to serve each of these people because together they represent the entity that you are trying to sue. This is also the case for instances of a trust. You must serve the trustees with these court papers, and it is advisable for you to cite the trustees because the trustees are, in terms of the law, considered to represent the trust. Where a person who is supposed to be served with court papers cannot be found, especially when a matter is starting out, meaning they'd have to be served with an application to start the matter or a writ of summons. Then the person who is bringing the matter can apply to the court for what is called substituted service. And in this application, the person would have to file an affidavit. In the affidavit, they will explain all the steps they took in order to try and serve this person directly. They will explain that the last known place of residence of the person was at plot 123 Palape, and that when they got plot 123 Palape, this person was not there, and therefore they asked the court that this person be served in some other manner. And usually substituted service is done by putting an advert in the newspapers. And by putting an advert in the newspapers and giving a certain deadline for the person to respond to you, then the court will consider that this person has been served. Meaning that if the person does not enter opposition or does not put in an appearance to defend, then the person who is bringing the matter is entitled to seek default judgment against the other party. Another instance of the process of service is where you know that the person you want to sue is not in the country. You then bring an application before the court for what is called an edictal citation. This is where you are saying to the court, I want to sue Masego, but I know that Masego is in South Africa, and therefore I am asking for an order from you as the court to be able to serve Masego in South Africa. The court will accept such service if the order has been given for edictal citation, where the service is done in terms of the law of South Africa. And this brings us to our next issue, which is how do you prove service? Where a person has been served in a different country, then there has to be an affidavit by the person authorized by the law in that country to serve. So, for example, if the people that serve in South Africa are also called deputy sheriff, then the deputy sheriff will prepare an affidavit explaining that they served the documents in terms of the law of South Africa, and they will explain what that law is in relation to the service that they did. They will then explain that they are entitled to serve in that manner and that they served within the allowed timelines as per the law of that specific country. Meaning that the time and days for service might not be similar to those of Botswana. But as long as it is that which is provided for in the law of the country where service is made, then that is proper service in terms of our courts here. Another way that service is demonstrated, where service is in Botswana, is by an affidavit of service by the person who served the documents. It is important here to note that when service is done on any party, then service has to be made by a person who does not have an interest in the matter. And by interest in the matter, we mean a person who is not a party to the matter. In other words, if I am the one who is starting a matter against Malaboro, I cannot serve Malaboro in terms of the law. Malaboro can be served by my attorneys or by a deputy sheriff I have appointed or a messenger, as long as it is not me. This is true no matter whether it is originating process or it is papers or documents filed as the matter continues. However, most of the time, even if there is direct service, people tend not to raise issue in order to move the matter along. The person who serves and is not a deputy sheriff has to put in an affidavit of service with the court to indicate where they served, when they served, and if the service was done on a company, they have to explain who they left the documents with and the assumed age of that person, which would be above the age of 16. In this affidavit, they also have to say that they explained to the person that they served what the document is in relation to. And they say this because in terms of the law, they do have to explain. If it is a writ of summons, you then explain this is a writ of summons brought by Bonono against you for the recovery of debt. If it is a notice of set down, you then explain that this is a notice of set down for your matter that is coming up on this day before this specific judge. In the affidavit of service, the person has to explain where they served, what time they served, in order to see that the service took place within the allowed times and days. And the person who has served has to sign this affidavit before a commission of oaths, and the commission of oaths would then sign that affidavit as well. In addition to this, in terms of the law, a stamp where the documents have been served on government or attorneys is enough proof to show service. And usually what is done is a copy of the first page of the filing notice with that stamp is then attached as an annexure to the affidavit of service. This is done simply as an extra precaution, but it does not mean that if such an extra is not added, then service has not taken place. A simple affidavit of service is sufficient. In relation to deputy sheriffs, a deputy sheriff does not have to make an affidavit of service when they've served certain documents. What they do is prepare what is called a return of service. And that return of service is not commissioned by a commission of oaths, is merely signed by the deputy sheriff, and it is accepted by the court. However, if the court or the registrar of court is unhappy with the manner of service, they can ask that the documents be served again on the parties. It is important to remember as a summary that when service happens, please receive the court papers and take the necessary action in order to protect yourself. And the reason why that is because you might think because you have refused court papers, it is not proper service. And find that at the end of the day, you have judgment granted against you because the other party was able to show that they served you without you actually being hurt. Therefore, take court papers, get advice on what steps you need to take, and then act accordingly. Always choose an address that is suitable for you so that you receive all your court papers and you are able to deal with your matters as and when they come. I hope this was useful, and please like, share, and subscribe. Thank you for joining me on my channel. Follow me on Facebook, Twitter, where I sometimes put in legal issues here and there and point out certain legal areas that I do not make videos on. And I appreciate your support. Thank you very much. Bye.